Liberties, rights, freedoms, and equality are the foundation of how we live, govern, protest, and protect one another in this country. And yet, they don't always move in harmony. Sometimes your freedom of speech runs straight into someone else's right to live without fear or harassment. Sometimes demands for equality feel like a threat to these individual liberties. These tensions are baked into the system. They're by design. We talk a lot about freedom of religion, freedom of expression, and freedom of speech, and those are essential. They're part of what we call negative rights, protections from government interference. The government can't censor you, force you into a religion, or punish you for protesting. That's the promise. But we also have positive rights, or at least the fight for them. These are rights that require the government to act, the right to vote, the right to public education, the right to equal protection under the law. These are about what the government must do to ensure fairness and opportunity. And that's how things get complicated, because the United States has never handed out those rights equally, not by a long shot. Our legal and political systems have long delivered very different outcomes depending on your race, gender, class, and the fight over how to address those disparities through policy, law, or culture is still raging. So the real work of democracy isn't just about preserving freedoms. It's about asking who has access to those freedoms, who's being left out, and what we're willing to do about it. Civil liberties are the basic freedoms the government ain't supposed to mess with. Things like speech, religion, press, assembly. Think of them as the hands-off clauses in the Constitution. The government can't take these from you without a fight, and usually without a lawyer getting involved. Civil liberties are born straight out of the Bill of Rights, which is the first 10 amendments to the Constitution. They spell out what the government can't do to you. It can't censor your speech. They can't search your home without a warrant. They can't throw you in jail without a fair trial. These are your individual protections.
The first 10 amendments to the U.S. Constitution, also known as the Bill of Rights, were ratified or passed over 200 years ago. But even though they're a bit, old, these first 10 amendments are still the most debated and discussed section of our Constitution today. So can you remember what they are? Let's take a look. The First Amendment is the freedom of speech, press, religion, assembly, and petition. This may be the most revered of the amendments. The First Amendment protects our rights to say and write our opinions, worship how we please, assemble together peacefully, and petition our government if we feel the need. The Second Amendment is the right to bear arms. The original intent of the Second Amendment was to protect colonists from the invading British soldiers, but it now guarantees that you have the right to own a gun to defend yourself and your property. The Third Amendment is called the Quartering Amendment. It was written in response to the British occupation and as a result of the colonists having to house or quarter soldiers in their homes during the American Revolution. Because of this amendment, our government can never force us to house soldiers in our home. The Fourth Amendment is the right to search and seizure. The police can't come into our home without a search warrant and take our personal property. Today, many concerns have arisen about our rights to privacy and technology. For example, can the government track your location with your smartphone, or can social media postings such as on Facebook and Twitter be used without a warrant? On to the fifth. It's all about due process. You've probably heard the phrase, "I plead the fifth," in movies or on TV. They're talking about the Fifth Amendment, which says that you don't have to take the witness stand against yourself if you may end up incriminating yourself. Okay, we're halfway done. The Sixth and Seventh Amendments are about how the legal system works. If you're accused of a crime, you have the right to a speedy public trial and an impartial jury. You also have the right to a lawyer and the right to take the stand if you choose. This is important because it will prevent the accused from sitting in prison forever and insists that the prosecution proceed with undue delay. The seventh says you have the right to a jury trial, where 12 impartial peers decide your innocence or guilt in the courtroom, as opposed to a judge doing it all alone. The Eighth Amendment prohibits cruel and unusual punishment. Is a death penalty cruel? Is it unusual? It's hard for Americans to agree on the definitions of cruel and unusual. The Ninth and 10th Amendments are called the non-rights amendments. They say that the rights not listed in the Bill of Rights are retained by the people in the states. You have other rights that are not listed in the Constitution, and the states have the right to make their own policies, like instituting state taxes. So, now you know all 10 amendments. Can you remember them all? If not, remember this. The Bill of Rights are a crucial piece of American history, and though society has undergone many changes these past 200 and some years, the interpretation and application of these amendments are as vital today as they were when they were written.
These protections were originally only about the federal government. The states were a different story. The Bill of Rights wasn't always the law of the land in every state. If you lived in, say, Mississippi in the 1800s, your rights could look pretty different than if you lived in Massachusetts. States could and did decide the extent of your individual liberties. That is, until incorporation came along. Incorporation is the idea that the Bill of Rights doesn't just limit the federal government anymore. It now applies to the states too. The Supreme Court didn't start deciding this until the 20th century. Bit by bit, case by case, they started saying, hey, states can't violate these rights either. It's called selective incorporation because it didn't happen all at once. One of the earliest and most important cases was Gitlow versus New York in 1925. The court ruled that freedom of speech and press are fundamental rights, which means states have to respect them, just like the feds do. Most of the Bill of Rights has been incorporated at this point, but not all of it. And because incorporation is a creation of the court, not the Constitution, it can be reversed, which means every generation of justices gets to shape how free we really are. Now, civil rights are different from civil liberties. Whereas civil liberties are about freedom from government interference, civil rights are about what the government must do to ensure people are treated fairly. This distinction becomes crystal clear when we talk about the 14th Amendment. The 14th Amendment is one of the most powerful tools in the Constitution. It was passed in 1868, just a few years after the Civil War, during the Reconstruction era. The country had abolished slavery with the 13th Amendment, but then came the question of what does freedom mean for the formerly enslaved? What protections do they have? What rights can they exercise? The 14th Amendment answered with a bold promise. It guaranteed birthright citizenship. Anyone born in the United States is a citizen, regardless of race or ancestry. This was a direct response to the Dred Scott decision that the Supreme Court had made, which had infamously declared that Black people could never be citizens. The 14th Amendment overturned that completely. And then it also said, no state can make or enforce any law that abridges the privileges or the immunities of citizens. It said no state can deprive any person of life, liberty, or property without due process of law. And it said no state can deny any person equal protection under the laws. That language has done a lot of heavy lifting over the years. It's the foundation for most of the court's civil rights rulings. It's how the court has struck down school segregation, discriminatory marriage laws, and unequal treatment in criminal justice. It's also been used to apply the Bill of Rights to the states through incorporation, which we just covered. In short, the 14th Amendment is both a sword and a shield. A sword that lets individuals and groups fight for justice in the courts, and a shield that protects them from discrimination at the hands of the state. Then you got the other big civil rights amendments, the 13th abolished slavery. The 15th gave black men the right to vote. The 19th finally extended the right to women. And the 26th lowered the voting age to 18. Because if you're old enough to die in war, you should be old enough to vote for the people sending you there. Liberty and equality don't always coexist peacefully. Liberty promotes individual freedom and self-interest. Equality demands uniformity and often government intervention. One says, leave me alone. The other says, step in and fix this. These values clash, sometimes subtly, sometimes explosively. Anytime the government tries to draw the line between protecting freedom and protecting fairness, you can't always have both at full strength. A government that guarantees total liberty might let powerful groups dominate. A government that insists on total equality might limit individual freedoms to make room for the collective good. It's not a simple balancing act. It's a constant negotiation. The fight is over when should government step in and when should it back off. Freedom of speech is a cornerstone of liberty. It's enshrined in the First Amendment. It's essential to democracy. But what about hate speech? What about language that dehumanizes and threatens or incites violence against marginalized groups? That's where equality steps in. If someone's speech is making it harder for others to live freely and safely, do we limit that speech or do we protect it no matter what? There's no easy answer, but there's definitely a trade-off.
Free speech. It's the thing everyone thinks they value until they hear something they don't like. And today, we're going to get into the nitty-gritty of the free speech battles happening on college campuses. "2017 was a big year for free speech. White nationalist rallies and the Take a Knee movement sparked tons of media attention and controversy. College campuses across the country, including where we are now and where I went to school, UC Berkeley, go Bears, are at the center of this free speech debate. It's the same story over and over again in the news. Protests erupt over a controversial speaker who comes to campus, sometimes shutting him down and sometimes resulting in violence. And this draws a divisive line between people who want to limit controversial speech at campuses and those who believe that anyone should have a right to speak freely, no matter how extreme their views. What exactly does free speech mean on college campuses? First, some background. Freedom of speech is protected under the First Amendment of the U.S. Constitution. It basically means the government cannot arrest or punish you for speaking your mind. You're totally free to bash whatever or whoever you want. The president, Congress, tech bros, decaf coffee, Florida. Anyway, the point is the government can't come after you for it. The founding fathers thought this was fundamental to democracy, and they were right. Without free speech, there couldn't have been the civil rights or women's rights to vote movements. And who knows, maybe our next president will be a woman. But to be clear, free speech just applies to government and government entities, which are places that are funded by your tax dollars at work, folks. And yes, public universities fall into this category. Private companies, on the other hand, can censor you all they want. That's why ESPN, for example, can fire a sports anchor for saying something that goes against their company policies. But that anchor can't get arrested for what she said. Or the NFL could make a rule banning players from kneeling, but players couldn't get arrested if they chose to do it. But there are some limits to free speech, like blackmail, making a threat, soliciting a crime, inciting violence, lying under oath, and violations of copyright are some of the things that are not allowed. And here's where a lot of the controversy on college campuses comes in: hate speech. Like this person who feels strongly that college campuses should be no place for hate.
Racism isn't welcome, bigotry isn't welcome on this campus, and we can't set a precedent for giving people who are espousing hatred to have a platform on this campus.
But the truth is, when it comes to giving speeches to crowds, for the most part, hate speech is protected. And just so we're all on the same page here, hate speech usually refers to attacks on people based on their race, religion, sexual orientation, gender disability, and the like. So, a speaker can totally say racist, homophobic, or mean-spirited things about groups of people. I mean, hey, that's pretty messed up, but it's also not illegal. It's super hard for someone to get punished for hate speech when speaking to a crowd. Basically, it can only happen if this speech immediately and intentionally provokes the crowd to commit a crime. So for example, a KKK leader is allowed to give a speech saying lots of terrible things about different races. But what would be illegal is if the speaker pointed to someone in the crowd and yelled, "Attack that person," and then the crowd actually did. Now, it's super easy to hate hate speech. It's mean, offensive, and can really hurt the people it's directed at. But there's a good reason why it's protected. Think about it. Do you really want to put the power in the hands of the government to decide what they consider hateful? Say we've got a president that finds hilarious parody videos like these SNL clips to be hateful and decides to make them illegal.
You know, I actually love football. I could have played. People say I remind them of an NFL player because I'm combative, I like to win, and I might have a degenerative brain disease.
Oh my God, what happened? What happened was you made Barack Obama angry. And when you make Barack Obama angry, he turns into The Rock Obama.
I mean, it wouldn't be America if we couldn't make fun of our own president. Okay, let's go back to college campuses for a second. Public universities, like where we are now, UC Berkeley, are public entities because they're funded by US tax dollars. So a public university can't deny any speakers based on their views, no matter how crazy or extreme they are. In fact, last year, Auburn University tried to get white nationalist Richard Spencer to stop speaking on campus, but a federal judge ruled that that was a violation of his constitutional First Amendment rights. But things get complicated when student or public safety is involved. Like when UC Berkeley had to dish out $600,000, yes, that's over $500,000, when conservative speaker Ben Shapiro wanted to come to campus. Could universities just use a threat of violence to shut down speakers whose views they don't agree with? And who should bear the cost? The universities, the speakers, or a combination of both? Free speech advocates believe a university must do everything in its power to allow and protect speakers. One of the most outspoken advocates is Robert Reich, an economist and professor at Berkeley who's known for his liberal views. We see him all the time on the news advocating for free speech for some of the people he disagrees with the most.
I tell my students all the time the best way to learn something is to talk to people who disagree with you, because that forces you to sharpen your views and test your views, and you might even come out in a different place. A university of all places is the locus where we want to have provocative views.
And do you really want administrators deciding who's offensive? I mean, where do you draw the line on hateful speech? If a liberal campus decides to ban Spencer, could a conservative campus decide to ban Colin Kaepernick or Hillary Clinton? Censorship goes both ways. So, what do you think about all this? How should universities handle controversial speakers?
Right to protest is sacred. It's how people demand change, challenge authority, and make their voices heard. But what happens when protests disrupt traffic, shut down streets, or create safety risks? Local governments often argue that restricting protests is necessary to maintaining public order. And sometimes those restrictions aren't neutral. They're used to silence dissent. That's where liberty and equality collide again. Whose safety? Whose voice? Whose rights take priority?
Ryan, do you remember this?
No, this is the first time I ever been. I didn't even, because I look at the maps and stuff and I was like, didn't seem like there's anywhere I could have fallen, but like, yeah, that was it. That's crazy.
Ryan Knight was paralyzed at a Black Lives Matter protest last summer in Tulsa. A new law in his state could make protesting a lot more dangerous.
So I felt like right around here, huh?
You feel like right here?
Damn.
The group had been marching through town with a police escort. The police claimed demonstrators veered off the designated route and onto the highway.
Yeah, actually, we came up that street, didn't we? We had to have. Yeah, I don't remember anything. That's crazy.
Videos taken at the protest last year show a chaotic scene. This angle shows some protesters were trying to let the car through before some started attacking it. In the chaos, Knight was knocked over the railing and fell onto the grass beneath the highway.
Next thing I know, I woke up in the hospital with a trach in my throat, and I couldn't move my legs or arms or anything. Sit. Good girl. It's okay. Come here.
Oklahoma is one of 11 states offering immunity to drivers who hit protesters with their car. This November, the law goes into effect to protect drivers who unintentionally injure or kill a protester if the driver felt that they were in danger. The law also punishes people found guilty of participating in riots with up to 10 years in prison. A riot in Oklahoma can be any 3 people who use force or threaten to use it. Oklahoma State Senator Shane Jett sponsored the legislation and sees it as a response to the Black Lives Matter movement.
Why did you sign on to this bill, HB 1674?
We had a specific situation where a family was caught in a riot situation where they were feared that their windows would be busted out and that they would be hurt. And so they felt like they needed to escape and didn't feel like they could escape from that situation, and they were in danger. And so the decision was, do we stand up for people who are disrupting? As I believe that you have the right to protest, you have the right to petition the government for redress of grievance, but you don't have the right to terrorize citizens while you do that. And so what we wanted to send a very strong message was law-abiding families in Oklahoma have the right to be safe and have the backing of the legislature, that they do not have to be terrorized in their own car, and they can extract themselves in somewhere where they literally have the right to self-defense.
Tulsa County District Attorney Steve Kunzweiler said in a statement to Vice News that he was concerned about people taking advantage of the law. In Ryan Knight's case, Kunzweiler says he declined to prosecute the driver because existing laws already allowed that driver to protect himself and his family. Senator Kevin Matthews agrees. The new law isn't necessary.
We already have laws that say people shouldn't hurt or harm you, shouldn't hurt or harm your property. I think that a judge can make that decision. It's a shame that we rushed to pass a law to specifically address protesting. But when are we going to make a law that allows us to be transparent with police officers that hurt or harm our children?
From your perspective, was this bill solving a current problem in the state of Oklahoma?
This was a solution looking for a problem that we don't even have.
She got her tongue out. Sort of jazzy-wazzy.
Why do you think that Republicans across the country are introducing bills like this? And what do you think it says about America and where we are as a country right now?
It seems backwards, and I honestly don't know why America is turning this way, but it just proves that there's not a level that they won't go to stop them from feeling uncomfortable.
Will you be back out protesting with BLM again?
Yeah, absolutely. I mean, I think that's their tactic. You know, they want to scare people to not show up, and you got to show up, you know. I mean, that's what I got to do every day anyway, just wake up and show up, you know. I didn't do that for a while. You know, I do it some days, I don't do it other days, but, you know, at the end of the day, you know, we're not dead. You know, we're still living, so we have to show up and do something, and if you believe in something, you should continue doing it. And if I didn't show up, then I feel that, you know, me being in a chair would be for nothing.
Let's take a beat and name some of the liberties the Constitution spells out. Freedom of religion, freedom of expression, freedom of speech, freedom of the press, and the right to assemble and petition. You've heard them before. They're the ones folks tend to invoke when their rights feel threatened. These are the foundation of civic life in the United States. They let you challenge power, question the status quo, and advocate for change. They also protect the unpopular, the uncomfortable, and yes, sometimes even the offensive. That is the cost and the power of a free society. Founders were clear. Government and religion needed some breathing room. People should be free to worship whomever they want, or not worship at all, without the state butting in. They'd seen what happens when church and state are tangled up. Europe was full of examples. Religious persecution, state-run churches, war. That history made them cautious. So they carved out religious liberty in the very first amendment. The goal was to protect individual freedom and prevent the government from taking sides in theological debates. First Amendment starts with the Establishment Clause. Congress shall make no law respecting an establishment of religion. That's the promise that the United States won't set up a national church like the Anglican Church in England. It also means the government can't favor one religion over another, or religion over non-religion. The second half is the Free Exercise Clause. The government can't interfere with your personal religious practice unless there's really good reason. That tension between accommodating religion and keeping it out of government is still playing out in courts and legislatures every single day. See the recent controversial laws about mandating the 10 Commandments in public school classrooms in Texas and some other states across the country. For generations, people have fought over what that balance should look like. Some want a high wall of separation, keep religion totally out of public life and public dollars. Others argue that the government should accommodate religious expression, even in public institutions. That's why you'll see lawsuits about school prayer, public nativity scenes, and religious clubs meeting on campus, or faith-based charities receiving government grants.
Good people of Arkansas and supporters of religious liberty, I present to you Baphomet.
What did Jesus say? In the last days, there would be a war on the saints. Here's a clear example of the war on the saints.
I think the way the state has been trying to frame our battle is one of the Satanic Temple versus Arkansas, or Satanists versus Christians. And what I'm trying to show is that that's not the case. And we're not protesting against, we're rallying for pluralism and real religious liberty. We are literally on the front lines in the war against encroaching theocracy.
The statue itself has these children like they're flocking to Satan. You know, we want our children to get to heaven. We don't want them in hell for all eternity.
Hi! The Satanic Temple is not a group of devil worshippers, but liberal political activists who oppose the increasing influence of the religious right in American politics. Based out of Salem, Massachusetts, and led by their co-founder, Lucien Greaves, today they're in Arkansas to protest at the state capitol in the name of constitutional rights. What's the mood like?
I'm not sure what the general mood is. I've been rather isolated since I've gotten in. This is the first time we're putting together our own rally, and we're doing exactly what the state politicians said would never happen, bringing our monument onto the Capitol grounds.
The monument depicts Baphomet, an anthropomorphized winged goat figure associated with occult and mystical traditions, with two children at his feet. Even though these activists don't actually believe in a physical Satan, they know that Christians do. And exploiting God-fearing Republicans' belief in the devil is one of their tactics. They harness the power of satanic imagery and symbolism in dramatic public demonstrations to draw attention to their left-wing causes. Their latest target is Arkansas, and a 10 Commandments monument, which was recently installed on the Capitol grounds, and which they claim, in isolation, violates the First Amendment's ruling on the separation of church and state.
The 10 Commandments monument is illegal if it remains up in exclusion to other monuments of religious expression. If they allow our monument to be erected on the same Capitol grounds, that would legalize the Ten Commandments, and it would also stand as testament to our respect for pluralism and religious liberty and First Amendment values.
So here it is in all its glory, the offending Ten Commandments monument. It's in the surrounding grounds of the Capitol. It's protected, as you can see, by these sturdy bollards because the first day it was erected last summer, a man drove into it with his car, destroying it. The Ten Commandments monument was a donation from an evangelical senator who claims it was not a religious gesture. It simply represents the morals that this great nation was founded upon. The Satanic Temple disagree. They think this seems like a very religious gesture, and they want proof that it's not. So they're offering a donation of their own, which happens to be a statue of Baphomet, and they think that if the Capitol rejects their donation, that proves that this gesture is a violation of the constitutional separation of church and state. The Satanic Temple was involved in a similar effort in 2015, which led to the removal of a Ten Commandments monument from the grounds of the Oklahoma state capitol. There are monuments to the Ten Commandments at government buildings all over America. I was allowed inside the Capitol building to meet Senator Rapert, the man who sponsored the bill to erect the Ten Commandments monument here in Arkansas.
Good afternoon, Senator. What is it about the Ten Commandments that being on the lawn in Arkansas that has upset other groups, especially the Satanic Temple?
Well, it's very important for you to know we have many monuments on the Arkansas Capitol grounds, but we did not have any monument that actually spoke to the historical and moral foundation of law. And so we decided that the Ten Commandments, which is one of the first recorded written codes of law ever, we thought that that would be a good and proper thing and very fitting. The bottom line is we have an act that created the Arkansas Ten Commandments Monument Act. The monument was put up and the monument will be defended. And if the Ten Commandments are good enough for the United States Supreme Court, it's good enough for the people of Arkansas.
Is Baphomet ever going to be allowed to be on the lawn?
Of course not. I've said it personally many times. It'll be a very cold day in hell before anyone is able to force us to put up a monument of a profane statue on the grounds of the Arkansas Capitol.
For the fundamentalist Christian counter-protesters from America Needs Fatima, this has nothing to do with First Amendment rights and everything to do with literal Satan. While Lucian and the Satanic Temple acknowledge they're using the spectre of Satan, somewhat ironically, believers on the other side see this goat-headed fellow as something much more real and sinister.
I think it could lead to a lot of darkness and open a floodgate to hell, honestly.
Is this the most effective way you guys can think of to furthering this cause? Have you thought about maybe sitting down and having a conversation, or is that not possible?
I think if most Christians are honest about it, they'll admit that they're just pretty much picking and choosing what they will believe and what they won't. And I think the more people become comfortable culturally identifying with their religions and realizing that they don't have to pretend they believe in things that are simply intellectually insulting today, that they can still have their ethics, their symbols, that they can still use this metaphorically to contextualize their lives, I think we'll find a lot of people identifying non-theistically with their religions. I think we're just a little bit ahead of the game.
When religion and governments clash, courts ask two questions. First, does the law or policy have a secular intent? In other words, is it about religion or is it about something else, like public safety or education? Second, if religious liberty is being limited, does the government have a compelling state interest? Is this limitation truly necessary to serve some fundamental purpose? If the answer is yes, the law might stand. If not, it could be struck down. This balancing test is how courts try to honor religious freedom and maintain order. You can believe what you want, practice your faith freely, and live according to your conscience. But the government won't and shouldn't officially endorse your religion. That balance is fragile. And when policies seem to lean too far one way or the other, people push back. Sometimes through legislation, sometimes through litigation, sometimes through public protest. The debate isn't over whether we value religious freedom. It's about how we want to apply it in a pluralistic society.
Can a state constitutionally deny funding to religious institutions? A state wishing to exclude religious participants from public funding must tread carefully between the First Amendment's religion clauses. In Espinoza versus Montana Department of Revenue, the state wants to keep a funding program separate from religious institutions in line with the Establishment Clause. But by excluding religious schools, does the state violate the Free Exercise Clause? The Montana legislature established a program to support students in private schools. Residents could claim a tax credit if they donated to an organization that funded scholarships for private school tuition. The Montana legislature directed that the program be administered in accordance with the state constitution's no-aid provision. The provision prohibited awarding state funds to religious schools. The Montana Department of Revenue established an administrative rule prohibiting scholarship recipients from using the funds at religious schools. As a result, Kendra Espinoza and other parents weren't permitted to use scholarship funds at a private Christian school. They filed suit against the Department of Revenue, and the trial court enjoined application of the rule. The Montana Supreme Court reversed and invalidated the scholarship program in its entirety. The court reasoned that the program was invalid under the state constitution's no-aid provision because it contained no mechanism preventing public funds from flowing to religious schools. The Supreme Court granted cert to consider whether the Montana court's reasoning violated the Free Exercise Clause.
Freedom of expression covers more than just speech. It includes the press, protest, and petition. It protects your right to wear a political t-shirt, march in the streets, and demand change from those in power. This freedom is the engine of democratic change. It allows the minority voice to be heard. It allows dissent, and it ensures the truth can compete in the marketplace of ideas. Even when it's inconvenient or uncomfortable, without expression, there's no accountability. There's no reform. There's no progress. When a government censors dissent, it sends the message that there is only one acceptable opinion. That's dangerous. The founders knew democracy only works if people can challenge their leaders. Freedom of expression is how we correct bad ideas, expose injustice, and push society forward. If all we hear is one side, especially the side in power, we lose the ability to grow and evolve, or even to govern fairly. All that said, our national record on protecting expression isn't exactly spotless. Historically, Congress has been quick to crack down on speaking out against the government, criticizing its leaders, protesting its policies, especially during wartime. And while the First Amendment says Congress shall make no law abridging speech, that hasn't stopped it from trying again and again.
What we're going to do right here is go back, way back into time.
The Alien and Sedition Acts made it illegal to speak, write, or publish anything scandalous or malicious against the government. They also gave the president the power to deport dangerous foreigners without a trial. That's a long way from freedom of expression, but it shows how fragile rights can be when government feels threatened. And until recently, most Americans probably couldn't tell you a single thing about these acts. They were largely forgotten, archival footnotes from a time when the ink on the Constitution was still drying. But in 2025, the Trump administration invoked the Alien Enemies Act, one of the few parts of that 1798 package still on the books, to justify mass deportations of Venezuelan nationals, citing national security threats. That move brought the act roaring back into the public spotlight and sparked widespread debate. Suddenly, a centuries-old law that many assumed was defunct was being used to reshape immigration policy in real time. It was a reminder that just because a law is old doesn't mean it's dead. And just because we forget about it doesn't mean it can't come back with real consequences.
Does the president have unchecked power to suppress free speech and deport non-citizens? President John Adams seems to think so. Amid the fiery tensions with France, Congress passes a series of laws limiting immigrants' rights and empowering President Adams to deport those deemed dangerous. Mr. Seeger presents Infamous History, the Alien and Sedition Acts, 1798. Critics accuse President Adams of silencing his political opposition and targeting potential voters for Thomas Jefferson. The laws also criminalize criticism of Adams's administration, leading to jailed dissenters and silenced newspapers. America's foundational ideals seem under siege. Controversy weakens Adams, sustains his presidency, and fuels Jefferson's electoral victory over Adams 2 years later, solidifying the Act's legacy as a cautionary tale of liberty sacrificed in the name of security.
Fast forward to World War I. The Espionage Act made it a crime to obstruct military recruitment or criticize the government. People were jailed for handing out draft pamphlets or giving speeches questioning the war. The message was to not cross the state. Not while we're at war, even if you're doing it peacefully, even if you're exercising your rights.
Another kind of disease is loose in the land. Suspicion, attacking all forms of dissent. Vigilantes, operating in the name of patriotism, pursue their own blacklist of enemies. Draft dodgers and war bond slackers. Pacifists who condemn war. Labor groups that insist on voicing discontent. The foreign-born. Wilson's fears of a brutalized, conformist America loom over the nation. The government acts to take the law out of the hands of the mob. The Wilson administration, under criticism as soft on pro-Germans, seeks and gets tough new laws suppressing freedom of speech and opinion. One controversial labor group, the Industrial Workers of the World, the Wobblies, is violently suppressed by mob and government. In Arizona, 1,200 members are expelled en masse to an army post in New Mexico for their preachments and practice of strike with anarchist overtones. Elsewhere, IWW offices are raided by federal agents, their officers arrested, including Big Bill Haywood, their leading figure. Socialist Party leader Eugene V. Debs, who got nearly 1 million votes for President of the United States in 1912, is arrested for a speech considered obstructive to the war effort, is later sentenced to 10 years in jail. With the prosecution of the dissidents, Wilson has both crushed the anti-war spirit and appeased the extremists.
The Smith Act went further. It made it a crime to advocate, abet, advise, or teach the violent overthrow of the government. That vague language was used to target communists, socialists, and labor organizers during the Red Scare. It triggered massive First Amendment battles and crackdowns on political dissent.
Imagine that one day you're summoned before a government panel. Even though you haven't committed any crime or been formally charged with one, you are repeatedly questioned about your political views, accused of disloyalty, and asked to incriminate your friends and associates. If you don't cooperate, you risk jail or losing your job. This is exactly what happened in the United States in the 1950s as part of a campaign to expose suspected communists. Named after its most notorious practitioner, the phenomenon known as McCarthyism destroyed thousands of lives and careers. For over a decade, American political leaders trampled democratic freedoms in the name of protecting them. During the 1930s and 1940s, there had been an active but small communist party in the United States. Its record was mixed. While it played crucial roles in wider progressive struggles for labor and civil rights, it also supported the Soviet Union. From the start, the American Communist Party faced attacks from conservatives and business leaders. as well as from liberals who criticized its ties to the oppressive Soviet regime. During World War II, when the USA and USSR were allied against Hitler, some American communists actually spied for the Russians. When the Cold War escalated and this espionage became known, domestic communism came to be seen as a threat to national security. But the attempt to eliminate that threat soon turned into the longest-lasting and most widespread episode of political repression in American history. Spurred on by a network of bureaucrats, politicians, journalists, and businessmen, the campaign wildly exaggerated the danger of communist subversion. The people behind it harassed anyone suspected of holding left-of-center political views or associating with those who did. If you hung modern art on your walls, had a multiracial social circle, or signed petitions against nuclear weapons, you might just have been a communist. Starting in the late 1940s, FBI Director J. Edgar Hoover used the resources of his agency to hunt down such supposed communists and eliminate them from any position of influence within American society. And the narrow criteria that Hoover and his allies used to screen federal employees spread to the rest of the country. Soon, Hollywood studios, universities, car manufacturers, and thousands of other public and private employers were imposing the same political tests on the men and women who worked for them. Meanwhile, Congress conducted its own witch hunt, subpoenaing hundreds of people to testify before investigative bodies like the House Un-American Activities Committee. If they refused to cooperate, they could be jailed for contempt, or, more commonly, fired and blacklisted. Ambitious politicians like Richard Nixon and Joseph McCarthy used such hearings as a partisan weapon, accusing Democrats of being soft on communism and deliberately losing China to the communist bloc. McCarthy, a Republican senator from Wisconsin, became notorious by flaunting ever-changing lists of alleged communists within the State Department. Egged on by other politicians, he continued to make outrageous accusations while distorting or fabricating evidence. Many citizens reviled McCarthy, while others praised him. And when the Korean War broke out, McCarthy seemed vindicated. Once he became chair of the Senate's Permanent Subcommittee on Investigations in 1953, McCarthy's recklessness increased. It was his investigation of the Army that finally turned public opinion against him and diminished his power. McCarthy's colleagues in the Senate censured him, and he died less than 3 years later, probably from alcoholism. McCarthyism ended as well. It had ruined hundreds, if not thousands, of lives and drastically narrowed the American political spectrum. Its damage to democratic institutions would be long-lasting. In all likelihood, there were both Democrats and Republicans who knew that the anti-communist purges were deeply unjust, but feared that directly opposing them would hurt their careers. Even the Supreme Court failed to stop the witch hunt, condoning serious violations of constitutional rights in the name of national security. Was domestic communism an actual threat to the American government? Perhaps, though a small one. But the reaction to it was so extreme that it caused far more damage than the threat itself. And if new demagogues appeared in uncertain times to attack unpopular minorities in the name of patriotism, could it all happen again?
Now, you know good and well the answer to this question is absolutely not. But we've gotten more precise about where the line is. The Supreme Court used to be hands-off when it came to government censorship. But over time, the court developed legal tests to figure out which speech crosses a line. So today, not all speech is protected, but the bar for restricting it is much higher. Okay, so the modern judicial standard is the Brandenburg test. In the 1969 case Brandenburg versus Ohio, the court overturned the conviction of a Ku Klux Klan leader who had made a speech at a rally. The state had convicted him, but the court said that unless the speech is directed to inciting or producing imminent lawless action and is likely to incite or produce such action, it's protected. That's the test we still use today. This test draws a clear line. You can say what you want, even if it's offensive or provocative, unless you're actively encouraging people to do something illegal and violent right now. Think about the January 6th Capitol riot. Prosecutors had to carefully examine whether speakers at that rally crossed the Brandenburg line. Did they merely express the outrage and political opinion? Or did they actively incite the crowd to storm the Capitol? It was both a political but also a legal question, and Brandenburg was the standard the courts had to apply. That case reminds us why the test matters. It protects speech, but it doesn't protect incitement. That distinction is what keeps free expression alive in a democracy, even in the messiest, most heated moments. So where do we draw the line between speech and action? Should people be allowed to burn the American flag in protest? Should they be able to burn draft cards? What about kneeling during the national anthem or staging a die-in at a city hall? Symbolic speech is a hotbed of controversy because it's expressive conduct. It gets people's attention, makes them uncomfortable, and forces a conversation. And because it often challenges national symbols, it raises questions about patriotism and decency, and of course, law and order. But the First Amendment doesn't only protect speech people like. It protects expression that provokes, that offends, and that resists. Courts decided that symbolic speech can be protected. In Texas v. Johnson in 1989, the justices ruled that burning the American flag is protected speech. You might hate it. It might feel deeply disrespectful, but it's political expression. And that's exactly what the First Amendment is there to protect. But not all symbolic speech is safe. In the United States versus O'Brien in 1968, the court upheld the conviction of a man who burned his draft card because the draft card was a government-issued document with functional value. Destroying it was illegal interference with the draft system. The takeaway is that expression is protected until it actively disrupts a vital government function.
Trump administration's effort to deport a Columbia University student protester moved to a New York City courtroom yesterday. Mahmud Khalil was detained on Saturday night by immigration authorities and taken to Louisiana. The documents obtained by CBS News show that the case against Khalil is based on a rarely used law. Lilia Luciano was in court for yesterday's hearing and has the latest. Lilia, good morning to you. What can you tell us?
Good morning, Gail. Khalil's legal team argues his detention is unconstitutional. On Monday, a federal judge issued a temporary order blocking Khalil's deportation. And in a courtroom in New York City yesterday, he ruled that Khalil, a U.S. green card holder, be granted at least 2 private calls with his attorneys.
For the first time, lawyers for Mahmud Khalil faced off against government prosecutors in New York City Wednesday in a case that has raised serious free speech concerns.
Release Mahmud! Right now! Release Mahmud!
Outside the court, hundreds of protesters gathered to demand Khalil's release.
Now are we going to stop?
The Syrian-born activist of Palestinian descent had been a prominent voice in the student-led demonstrations at Columbia University last year.
This is a movement, an anti-war movement.
Ramzi Qasim is one of the lawyers representing Khalil.
He was never detained, arrested during the protest. No. He was not charged with a crime.
No, Mr. Khalil was never charged or convicted of any crimes. And so what did he do to deserve this? The answer is nothing.
But Trump administration officials disagree, calling Khalil a Hamas sympathizer, even accusing him of handing out the terrorist group's propaganda.
We're going to kick you out. It's as simple as that. This is not about free speech. This is about people that don't have a right to be in the United States to begin with.
Documents obtained by CBS News show the government is basing its case against Khalil on a seldom used section of the Immigration and Nationality Act.
which permits the Secretary of State to deport someone if they believe that the person could harm U.S. foreign policy interests.
There are no national security or foreign policy implications here. People are entitled to their viewpoints and they're entitled to express them, and they shouldn't be punished by the government for doing that. They shouldn't be incarcerated or disappeared or moved 1,000 miles away from their home.
The judge has not yet ruled on his lawyer's request to have Khalil moved back from Louisiana to New York. Khalil's attorneys questioned the administration's claims that he ever distributed any Hamas propaganda, urging them to show any evidence if they have it.
Martin Luther King Jr. once said, "We may have all come on different ships, but we're in the same boat now." That quote hits at the heart of the American promise. Everyone deserves equal treatment and equal opportunity, no matter where they start. Equality doesn't mean we all get the same outcomes, but it does mean we should all be playing by the same rules and getting the same protections under the law. Egalitarianism is the idea. It means that every person should have the same legal standing and political voice, even though we know that's not how things play out in practice. Some people have more money, more access, more influence. Others face systemic barriers because of race or gender, sexuality, disability, or class. And when those barriers go unchecked, you get political inequality. The Supreme Court has had to wrestle with a central question. When can the law treat people differently? And when does that treatment cross the line into unconstitutional discrimination? To figure that out, the court has created a framework, a kind of legal sorting system for evaluating laws that classify people into different groups. This framework helps courts determine how skeptical they should be of a given law based on the type of classification it uses. It all comes down to the risk of abuse. Some classifications, like race, have been used historically to marginalize and harm, so the courts treat them with the most suspicion. Others, like age or income level, might be less prone to abuse, so the courts give the government more leeway. This framework has 3 levels: strict scrutiny, intermediate standard of review, and rational basis review. The higher the risk of discrimination, the higher the level of scrutiny government must pass. And that means the government better have a very strong, legitimate reason, and the policy must be narrowly crafted to achieve that goal. Let's break it down. Race and ethnicity are suspect classifications. That's legal shorthand for high risk of discrimination. Any law that treats people differently based on race or ethnicity is immediately suspect. It triggers strict scrutiny, the highest standard. That means the government must show a compelling interest, and the law has to be narrowly tailored. Most laws that fall under this standard don't survive, because history has shown us that racial classifications have almost always been used to exclude, exploit, or oppress. Strict scrutiny is the legal system's way of saying, you better have a damn good reason, and it better be airtight. Quasi-suspect classifications don't carry the same red flag as race, but they still raise concern. The most common example is sex or gender. Courts recognize that gender-based laws have often been rooted in outdated stereotypes, so they require more than just a casual justification. The government has to meet intermediate standard of review. That means it must show that the law serves an important government interest and is substantially related to achieving that interest. It's a step down from strict scrutiny, but still no free pass. Courts take a long, hard look at laws that treat people differently based on identities like gender. Now, non-suspect classifications include things like age, disability, or economic status. Laws that draw distinctions based on these characteristics are reviewed under the rational basis test. That's the easiest hurdle for the government to clear. The state just has to show a rational reason for the law, something that's not totally arbitrary or absurd. And most of the time, the courts will defer to the lawmakers here. That's why policies that impact the elderly or the poor or people with disabilities don't always get the same level of scrutiny, even when the impact is significant. Egalitarianism has been one of the most contested ideas in American politics. A lot of people think equal means identical. Same rules, same treatment, same standards. But others argue that real equality requires taking people's different starting points into account and adjusting policies to address historic or structural disadvantages. This is where the conversation shifts from formal equality, same rules for everyone, to substantive equality, equity in outcomes. And that's where political fights get messy. Outcomes are the actual results people experience in real life. Access to education or not. Job opportunities or not. Healthcare, housing, wealth, safety, and justice. We may all start under the same law, but the outcomes tell us a different story. And this is where things get political fast. Some argue that disparities in outcomes signal a broken or biased system that needs reform. Others insist outcomes reflect individual choices, hard work, or merit. Others believe the gaps are too wide and too deeply rooted to close without big government intervention. But the U.S. is built on a cultural foundation of rugged individualism, the Protestant work ethic, capitalism, meritocracy, and deep skepticism towards government interference in business or culture. These beliefs shape how we define fairness, and they have real consequences. They've helped construct a system where some folks walk a smoothly paved trail, while others face steep, winding roads full of obstacles. The outcome is personal and political. So when we talk about equality, we have to ask, equality of what? Opportunity, access, outcome, and who's responsible for fixing the path? Disparate outcomes don't just fall from the sky. They're the result of two forces working together: individual prejudice and institutional influence. One without the other is damaging, but together they shape who gets access, who gets protection, and who gets left behind. On the individual level, we're talking about prejudgment, biases or assumptions people make based on identity, race, gender, religion, disability, you name it. These personal prejudices influence how people treat each other in schools and workplaces and courtrooms and at the voting booth. But prejudice alone doesn't create systems. That's where institutional power comes in. Institutions, governments, corporations, schools, media have the power to enforce rules, control narratives, own resources, and decide who belongs. When those institutions are shaped by or built on prejudice, even unintentionally, they start locking in advantages for some while putting up roadblocks for others. Control of resources, control of reality, the ability to decide who gets a voice. That's where bias becomes structure, and where liberty, rights, and equality start to drift apart. We've been talking about outcomes, not just the promise of rights, but how they actually play out in people's lives. And one of the clearest examples of that is Title IX. Title IX started as a simple ban on sex-based discrimination in schools that take federal money. Fiscal federalism, y'all. But it grew into a powerful legal tool to fight inequality in education. From athletics to admissions to harassment policies, Title IX has reshaped what opportunity looks like in American schools. It's proof that a single statute, when taken seriously, can ripple across generations.
So you might think Title IX is this 1970s law about women's and girls' access to sport, but it is about so much more. It is about sexual violence. It's about transgender rights. It's a piece of legislation that affects children, parents, professors, coaches, and it has transformed the world that we live in today. Title IX is a federal law meant to prevent gender and sex-based discrimination in entities that receive federal assistance. The first chapter of Title IX's implementation is really associated with access and equality in sports. Catherine Switzer, this female runner who's told you can't run the marathon, she actually signs up under her initials a few years earlier and runs the Boston Marathon.
The world's most famous foot race even attracts a leggy lady, Kay Switzer of Syracuse, who did.
But there are lots of stories like that. And what's really interesting is that as women like Switzer are pushing back on these assumptions that girls and women can't or shouldn't be physically active, they are succeeding. But Title IX almost immediately faces resistance. So you see during the 1980s that there are movements to kind of constrain the reach of Title IX. For example, there's one case, Christian college called Grove City College, and Grove City College pushes back on the directive that they have to comply with Title IX regulations. They say, we don't actually have to comply because the only federal aid is these direct grants to students, which happen through this one office. But ultimately, it is decided that that doesn't stand, and that once federal money flows into an institution, it might go to a scholarship or a grant, but it flows throughout the institution and has impact, and so thus they are kind of beholden to Title IX.
Today, I'm directing every agency and executive department of our government to strengthen their enforcement of Title IX within the next 90 days.
In the 1990s, you start to have both kind of more rules regulating how Title IX is imposed, but there's also something new afoot, which is that Title IX starts to be used much more expansively around issues of sexual harassment and what comes to be known as sexual violence on campus. And so you see the expansion of this legislation to be applied where there might be harassment, either by teachers or by peers, that creates an unfair, discriminatory environment. So if you think that early on, Title IX and sex-based discrimination is basically thought of as girls not getting an equal shot, by the time of the Obama administration, it's being expanded to say, hey, sexual orientation counts under this rubric. Hey, gender identity counts under this rubric. So they are both expanding the definition of what constitutes sex-based discrimination and continuing the fight for equality in sports. One of the signature moves of the Trump administration is actually to roll back Title IX protection, to remove transgender people. And then the second one is a series of decisions to make reporting of sexual violence more difficult.
There is no way to avoid the devastating reality of campus sexual misconduct. Lives have been lost. Lives of victims and lives of the accused.
So today, the most intense battles over how Title IX should fairly be carried out are absolutely about transgender rights. Today, we're talking about sports teams again. And now one of the most kind of hot button issues is about what is fair in terms of gender equality and inclusion of transgender athletes. The most high profile case is about Leah Thomas, a transgender woman swimmer at the University of Pennsylvania. immediately was a lot of blowback about this being a kind of unfair advantage because Thomas retained, critics say, much of the advantage of her originally male physique. It's really been an issue which is kind of testing what the purpose and the limits and the proper implementation of Title IX is. So I think it's important to realize that for every step forward that Title IX has made in terms of safeguarding gender equality, there has been pushback and there has been backlash. And depending on the historical moment, some of that backlash has been more successful than others. We know from the history of Title IX that there can be real change, real institutional transformation can happen.
Rights, liberties, freedoms, and equality are not finished products. They are living concepts shaped by conflict, by compromise, and by courageous people who refuse to accept injustice as inevitable. If there's one thing to take away from this, it's that the principles enshrined in the Constitution are only as strong as the people willing to defend them. They don't protect themselves. They require vigilance and participation and the courage to call out imbalance when we see it. The future of freedom depends on what we do with what we know. It depends on whether we're willing to identify outdated systems, expand access, and keep pushing. Keep pushing. So, in my best JFK impression, don't just ask what the government owes you. Ask what you owe the democracy you are living in, because power by design belongs to the people, which means it belongs to you too.